Good afternoon. In the second panel today, we're going to build on some of the themes that David Loffman spoke about in his keynote address. And we're moving from opportunities created by global trade to risks created by global trade. And you heard discussion from David about the economic sanctions and export controls and cybersecurity risks. And those topics are going to be among the topics covered by this panel. Grayson and I are very happy to be joined by some of our colleagues from our New York office today, Henry Clem and Mauricio Paez. Grayson joined Jones Day when I did back in February. He covers sanctions issues, export control, False Claims Act, government contracts, and cybersecurity issues. And today he's going to discuss how regulatory developments are posing a threat to international business, including discussion of new sanctions, some of the challenges that are created by the export control reform that you heard about on the first panel, CFIUS trends, and cybersecurity issues for government contracts. Next, Henry Clem from our New York office, who deals with regulatory enforcement and corporate governance issues, is going to provide an update on U.S. enforcement trends specifically related to sanctions and anti-corruption issues. And finally, Mauricio Paez from our New York office, who advises companies on data privacy, cybersecurity, information management, and cyber governance issues, is going to talk about privacy and cybersecurity updates, including the evolving landscape that we heard some of issues about from David Loffman. Unlike the first panel, we're going to go all the way through the discussion of the slides here and then take questions. And those of you on the webinar, if you want to send in questions electronically, we'll get those and we'll try to address those at the end of the presentation of the slides. With that, I'll turn it over to Grayson.
Thank you, Laura. Let's go to the sanctions section. So one of the major developments that has happened in the last few years, as we discussed this morning, has developed with sanctions, and not only in the potential lifting or easing of sanctions, but also in new sanctions that have been imposed by the government. And I figured we would start today's discussion off by going over some of the developments in the Ukraine and Russia-related sanctions. All throughout last year, in response to the actions in Crimea with Russia, the government has steadily increased its restrictions put in place regarding Russia and related entities. And these have really taken three different forms. The first is a series of executive orders and regulations that have targeted different entities for sanctions. The second is that there has been a general policy of shutting down exports to the region of sensitive items, either under ITAR or EAR regulations. And then finally, and this one is the one that's most often overlooked, there was actually some legislation passed by Congress, the Ukraine Freedom Support Act, that lays the groundwork for kind of Iran-like extraterritorial sanctions. It has not really been enacted because right now it's really focused on the defense sector and the energy sector. But the framework is in place, much like the Iran Sanctions Act, for these secondary type sanctions to take place regarding Russia. Next slide. So we'll start by just getting a general overview of the traditional sanctions that were put in place. These include putting individuals and entities on the SDN list, which I think most of us understand basically cuts that individual or entity off from any type of business. They really focused on government officials and the sectors of financial, transportation, defense, energy, and electronics. They've also put, and this is somewhat of a new concept, they've put an embargo on the region of Crimea. And this, in addition to BIS's listing of certain entities on an entity list, reflects a different approach here. And what I mean by that is BIS will put entities on the entity list, much like the SDN list, but what they've done in the last couple of weeks is they put an oil field on the entity list, which is different than the way that they've handled it before. And when you look at what you can and can't send to the region, not only do you have to screen against country names and individual and entity names, but now you have to figure out a way to actually screen to see if some transaction involves Crimea or a specific oil field. which is causing all sorts of issues as far as compliance is concerned, because most programs are not set up to take that into account. We'll get to a little bit to that, more on that in a bit. Finally, the sanctions involve the SSI list, the Sectoral Sanctions Identification List, which are what is being called by the government more of a smart sanctions approach. I think probably most people are familiar who deal in this area with the way the SSI is set up. It's different than the SDN. There are 4 different directives, and if your company or your name is on one of these lists, different restrictions apply to you. It could be from short and long-term debt restrictions to a restriction on working in certain areas such as offshore drilling, Arctic development, shale development, industries that the U.S. is trying to target for political reasons against Russia. Go to the next slide. One of the issues I was just talking about with the Crimea sanctions, the government has recognized that it's difficult to implement this, and so it's put out some instructions and directions on how to help handle these regarding Crimea. The first, of course, is a warning, though, and I think this is a sign of things to come. They're warning that they're seeing activity relating to Crimea that is similar to what they have seen with Iran, and by this I mean the stripping activity with SWIFT transactions. As I think probably most people know, with the SWIFT transactions, the problem that occurred with Iran is that when they were making these financial transactions, they would remove references to Iran, let them go through, then it would go through a U.S. bank, it would be a problem. OFAC is saying they are seeing the same issue happening with Crimea. So this is a shot across the bow. It's a warning that likely we're going to start seeing enforcement action against this type of activity going forward. Also with this announcement, they're giving instructions, and this goes to the question earlier that was more cybersecurity, but what type of due diligence and what type of actions does a company have to take regarding this and the knowledge level of sanctions? And OFAC is saying that U.S. companies should actively educate their overseas partners when appropriate regarding the limitations relating to the Russian and Ukraine sanctions. So also, moving away from Russia and Ukraine, there's also been activity in a new area in this hemisphere, and that's the sanctions that were announced earlier this year against individuals in Venezuela. This is not likely to have much practical impact on anybody out there in this room or for businesses. However, it is a sign of a new area, a new front being opened up in OFAC and in sanctions. It's a sign that they were also looking at the Western Hemisphere and issues that are happening here. It's very political in that it relates to Chavez and the issues that are going on there. And it could be a sign of more developments and more sanctions in the region. Next slide. And here is one of the bigger developments, I believe, that we're going to be focusing on in the next few years. There's a new executive order that went out in April 2015 that really lays the groundwork for the government to be able to sanction individuals and entities that are found to engage in certain cybersecurity activities. This slide contains a lot of the basic information about it, but the takeaway here is that there's a very interesting provision that the government can use, and that's that they can go after the entities and individuals who engage in cybersecurity and cyber threats and cyber intrusions, but they also have the authority to sanction entities that benefit from cyber intrusions and cyber threats. And it will be very interesting to see how they use that going forward. And no one's been named under these sanctions yet, but if we go to the next slide, probably a lot of people saw that in the last few weeks there's been a lot of chatter around the circles that we may be getting ready to impose some of these cybersecurity sanctions on entities and individuals in China that relate to all of the activities that we've seen here recently. The government believes that the Chinese are behind a surge in cybersecurity breaches that have occurred recently, and they are talking about potentially putting these sanctions in place as a warning to China, and also, I think as you heard David talking earlier, as a sign to U.S. businesses that the government is supporting them in this fight and that they're not fighting it alone. So we're going to move now from sanctions to export control reform. And whereas earlier today we were talking about some of the positives, I think Mike was talking about some of the positives from export control reform, I'm going to focus more on the negatives and some of the challenges and issues that we've had. As Mike talked about, one of the issues or one of the aims of export control reform was to simplify things. It is somewhat difficult that there are at least 3 agencies, 3 different regulatory regimes, and if you treat each sanctions regime as its own regime, just an enormous amount of complexity as to how you deal with export control reforms. And even after ECR, as it's been implemented, you still have multiple export regimes, multiple agencies responsible for these regimes, and there is still a lack of clarity as to what is controlled, who controls it, and why is it controlled. In fact, in certain instances, now you just have another list that you need to worry about of the stuff that they moved from ITAR to EAR, but put in its own separate category. So whereas before you had USML, CCL, now you've got those and the 500 and 600 series that you worry about that have their own set of rules and regulations. Next slide. And then more specifically, and this we could talk probably for a full day on these issues, but some of the steps they've taken in actually trying to reform export controls have been questioned by the industry and by companies that are subject to these rules. One of the bigger ones is the fact that in ITAR and the public domain definitions that they've come out with, they have put in a proposed rule that if something has been publicly released to the public domain, you have to check with ITAR, you have to check with DDTC first to make sure that it is okay that it was released. As you might not be surprised, that has caused a lot of uproar, especially in the arms industry, and complaints that this is a prior restraint on especially information and technical data that could be posted in the public domain. One of the other issues, and this is a big one, is the cybersecurity regulations that they have proposed. This is not so much an effort of ECR, but rather it's to implement an international treaty that regulates this type of activity. But the issue is that they've used such a broad definition of what cyber intrusion software is that it's wrapping up all of the good guys with the bad guys as well. And companies are saying, if you control this way and you put these controls in place, we're not going to be able to test and attack our own software to find out where our vulnerabilities are, and it's going to make things worse. So just this morning, Commerce came out and said that they're going to be looking back at this and trying to potentially revise it. And there's been other issues that have come up as well. And one of the big criticisms of ECR is that it does complicate things a bit. And whereas large companies with a very established program may have the resources to be able to understand and implement ECR, smaller companies are really at a disadvantage. To the extent they already had issues or just got their arms around ITAR, now they have a whole new set of regulations to try and understand, and they're constantly changing, and it's very difficult to devote the resources that are necessary. We'll next talk about foreign investment, and we'll focus on CFIUS first. CFIUS, as most people know, is an interagency committee that is granted authority to review corporate transactions where a foreign buyer is buying a sensitive U.S. business. It's a voluntary submission, but the issue is if you don't submit and get into the safe harbor, then the committee can require certain actions in the future, including unwinding a transaction. So most people go through the process if it's appropriate. I'm not going to really spend a lot of time talking about the details of CFIUS, but some of the trends that we've seen is basically that there are more filings being made with CFIUS. The filings are taking longer. The filings are going more into the investigation phase than they were earlier. The definition of national security is expanding. We've seen that it moved to locations, areas that are close to sensitive land or installations, sourcing issues, and cybersecurity are all issues that are now being brought under the national security umbrella with CFIUS. The other issue is, that we have to face now, especially as we work through our own CFIUS applications and notices, is what about a government shutdown? Back when this happened a couple of years ago, that really increases the length of time that is involved in a CFIUS notice and application, and the government doesn't give a pass for when it's shut down because these are statutory deadlines. We've also seen increased mitigation. Again, this is likely in response to the increased definition and expanding umbrella of national security. We've seen more aggressive attempts by CFIUS to require mitigation as well. Next slide. I want to spend a few minutes talking about foreign ownership control or influence, or FOCI. As many people may know, as some don't, it is possible for foreign companies to acquire U.S. companies that have classified materials and have a facility clearance. It is a rather cumbersome process that you have to go through with DSS to get to put this in place, and the idea is that DSS has to make its own affirmative decision to continue the clearance once the company is acquired by a foreign entity. The issue is, if you have foreign ownership, control, or influence, you have to mitigate that to DSS's satisfaction. Because a foreign person cannot have a security clearance, a foreign person can't have access or control or influence over classified materials. So there are certain measures that a company can put in place, from a resolution all the way up to a proxy board, that basically puts separation between the international and foreign influences and the classified materials. The real trick, though, is that you have to work with DSS to get them comfortable in understanding and okay with the structure that you're going to put in place after you have this acquisition. And then the final slide is that there is, as you probably can see, some interaction between CFIUS and DSS on this FOCI acquisition issue. There's now an interim rule that is in place that requires DSS to coordinate with CFIUS in working through this material. CFIUS is up against statutory and regulatory deadlines, whereas DSS is not. And those of you who have worked with DSS know that they don't always work as fast as you might want them to. So this interim rule does require DSS to work with CFIUS and to prioritize those applications that are going through a CFIUS process as well. One of the takeaways from this is that it's virtually guaranteed that if you have a DSS issue, CFIUS is going to know about it, which will sometimes increase the likelihood that you want to file a CFIUS application. And then next, I'm going to talk a little bit about cybersecurity for government contractors. Mauricio is going to handle the cybersecurity as a larger issue, but there are specific requirements that apply for contractors that go above and beyond those that apply to regular companies. Contractors hold sensitive, controlled information from the government, and so it's not a surprise to hear that the government requires them to take certain extra steps to protect this data. Now, I want to make a note right up front here. I'm not talking about classified data. Classified data is in its own realm. It's in its own arena, and that's not what we're talking about. We're talking about the information that is in between classified and non-governmental. There's a wide range of information that is controlled. It could be export controlled. It could be for official use only. It could be anywhere in between classified and uncontrolled completely. But there are certain obligations that a contractor has to protect that data and to report if there are any breaches that are associated with that data. And it is a wild and adventuresome ride to see how the government has tried to address this. There is no doubt they are playing catch-up at this point, and as you hear about all the breaches that have impacted the U.S. government, they are really trying now to make this a priority. But it started really back in 2010 with an executive order that said, basically, this is important, we got to get our hands around it. And then, as usually happens, DoD was the first to take the lead on this, and they came up with DFARS 7012, which summarized, basically points to the NIST standards that David was talking about earlier, sets them as a baseline for, or sets certain NIST standards as a baseline for contractors, and then imposes a 72-hour breach notification requirement, meaning that if a contractor has a breach that accesses this controlled material, they have 72 hours to go to the government and tell them about it, and they have to keep the data related to that breach stored indefinitely. Other agencies like the GSA have put similar provisions in place, but they have not taken the steps that DoD has to really get their arms around it. Next, we have a grand plan that the government has put in place to basically update the NIST standards, get all agencies to agree to the NIST standards, and then later come up with one FAR clause that will apply to all contractors that will wrap up what they need to do for cybersecurity protection and reporting. This NIST that's up on the board here is different than the NIST standards that were applied earlier, and the recognition is the ones that were earlier were the ones that applied to the government itself. This one is ones that apply to contractors. And the idea here, and what the government's trying to do, is to prevent and avoid contractors having to go out and develop an entirely new system. And so these are the standards that must apply. NARA is the agency that is handling, kind of spearheading what the agency coordination, and then the OMB is working with NARA to help come up with the rules, the requirements, and the eventual FAR provision that's going to go in place. Now what you see up here, the DoD interim rule that was put into place just last month is basically updating that 7012 clause to say, here's the new NIST standards that are in place. They also apply to your cybersecurity reporting requirement. And what is probably more troublesome is they've expanded the definition of what is controlled and what needs to be protected from just data that was controlled for export control reasons or other reasons to basically anything important to the government. And that is a very hard standard to try and understand what they're trying to get at and what somebody is required to protect, but that's the way they're going with it for now. I think that brings me to the end, right? Okay, and so with that, we're going to turn it over to Henry, who's going to talk about some enforcement trends in the area.
Good afternoon. My father was the middle of three brothers, and he told me many times that as the middle child, you often have to compromise and learn how to get along. And I was told when I sat down here that I needed to hurry up because they both had a lot more to say than I did. So I know what he's talking about. So overall enforcement trends. I thought I'd talk a few minutes about as commerce has globalized in the last 20 years and the administration has begun more vigorous or increasingly vigorous enforcement efforts in the wake of the financial crisis. What are the critical things that you kind of see when you look across a lot of the agencies and civil and criminal prosecutions by the department? When I say a lot of the agencies, obviously OFAC, FinCEN, the SEC, all the banking agencies, and the like have adopted this. Mary Jo White stole the phrase from Ray Kelly or Commissioner Bratton back in New York about broken windows policing, and the idea that if you clean up a neighborhood by making sure you stop the people that are breaking the windows, that mentality will permeate throughout the neighborhood and will create a better environment, a better quality of life, and all those other things. Having lived in New York for 25 years or 26 years now, I can attest that that's relatively true when it comes to community policing. The question that now is being posed is whether or not that works when it comes to white-collar matters and governmental matters, and I think that the evidence is pretty mixed. Typically, if you think about a turnstile jumper, they're sort of intentionally jumping that turnstile. The kid that's throwing the rock through the window is intentionally doing that and knows that he's picking up a rock with the view of destroying somebody else's property. I think there's a little bit of a challenge going on here because I think most people in corporate America would say that civil and criminal enforcement now has gone beyond that and is trying to reach conduct that nobody ever really intended, where nobody intended to violate the law. Whether or not it's because of a weakness in a compliance program or simply somebody at the end of the pier not getting the message, it seems to be the increasing number of cases. Secondly, in the wake of the crisis, there's tremendous political pressure to constantly set new records for the number of cases brought, the amount of economic penalties, the number of individuals prosecuted, all those things that the gentleman from the Department of Justice referred to in connection with the Yates memo that came out last week. Further, in the wake of Eliot Spitzer and now the New York Department of Financial Services, the idea of multiple agencies getting into the act all the time seems to permeate things. And I'll come back to the issue about individual liability. And this all ends up, if you take away the intentional wrongdoing, to begin to focus on the scope and effectiveness of corporate compliance programs. In particular, the SEC, the banking regulators, the CFTC, and others have really focused on or demonstrated a proclivity to make the effectiveness of a compliance program the centerpiece of a prosecution. And despite the company's best efforts in attempting to do that, these things often find their ways into that. And I thought I'd spend a few minutes addressing some of the key recent enforcement actions that support my theory. I have discarded all those that don't. So if we just talk about some of the sanctions enforcement efforts, Schlumberger oil field, the situation there, Schlumberger, their BVI subsidiary engaged in a number of transactions over a long period of time that involved Iran and Sudan business that the U.S. parent couldn't engage in. The company was prosecuted for facilitating those things where people in the U.S. subsidiary were routinely approving capital expenditures or working to disguise capital expenditures for operations in those countries. The people in the United States approved the transfer of equipment from foreign facilities into sanctioned countries. They made a number of business decisions about projects, and they provided technical services for repair to complex products in those countries. In the enforcement action, the OFAC makes the point that senior management knew and failed to enforce the company's existing compliance program, and that was one of the reasons that the sanction wound up at $232 million. In some ways, this case stands for nothing but the old talisman that you can't do indirectly what you can't do directly. In many ways it does, but I think that the vigor with which they pursued the company and the individuals and the amount of the sanction there demonstrate that. In Commerzbank, of course, is the German bank that had a relatively small U.S. dollar clearing business. And when I say relatively small, compared to the players in the area, the major banks, the 5 or 6 major banks, I think Commerzbank's U.S. dollar clearing business was probably less than one half of 1% of some of the major banks. Nonetheless, after a case involving ABN in 2005, which involved stripping, and we heard that referred to earlier, the process of removing the information from SWIFT messages to obscure who the transmitting banks and the receiving ultimate beneficiaries are. After that, Commerzbank embarked on a course of business over a period of years that, at least according to OFAC, management knew or had reason to know was improper. Indeed, I quoted here a couple of my favorite emails. One German executive writing to another one, if for whatever reason Commerzbank New York inquires why our turnover has increased so dramatically, under no circumstances may anyone mention that there is a connection to the clearing of Iranian bank money. Not too helpful when you find that. They also referred repeatedly to the safe payment solution. The safe payment solution in their emails was routing payments through SPVs that were controlled by an Iranian company that the bank knew was subject of sanctions. Really, this is a case about circumvention, and the other thing it demonstrates when you look at the list of agencies that were involved is the now routine, some would say piling on, but joint law enforcement effort. UBS. This case is actually a little bit of the tail, the tip of the tail of the larger UBS case. The company was fined, the bank was fined $1.7 million for processing 222 securities transactions related to an individual that was designated as a suspected terrorist. That individual was on a number of watch lists, including the Swiss watch list. The bank in Switzerland made scrupulously sure that they complied with Swiss sanctions law, but nonetheless facilitated U.S. securities transactions while knowing that that the individual was subject to U.S. sanctions. The order goes out of its way to make it clear that the compliance department in Switzerland was fully aware of the designation, but failed to implement measures to prevent the conduct. My last one, just going to show that any size transaction will, in the sanctions area, will lead to a fine. PayPal was fined $7.7 million for processing 600 transactions, actually 736 transactions, totaling $58,000. So the average size of those transactions is not too much. But the individuals that they processed them for were located in Iran, Cuba, and Sudan, and PayPal's compliance software did not have the capability of catching that information. As a result, the company paid $7.7 million in sanctions, not a good ratio. Turning to anti-corruption, anti-corruption has become an enormous source of revenue for the United States government. I have some slides on that in a few minutes. And their willingness to pour resources in this has grown tremendously in the last 5 years. And what does that result in? It results in a lot of prosecutors and a lot of FBI agents and a lot of other agencies that are involved, including the SEC, many of which have limited experience prosecuting these cases. So it has led to an awful lot of looking at what even 5 years ago the government would never look at in detail. And I find this one particularly interesting because, of course, the FCPA has been the cornerstone of the government's You've Got to Self-Report program. And you'll see some of the cases that they're now bringing kind of scratch your head. Why would you self-report if you're going to suffer these kinds of sanctions? So obviously there are the two provisions, the anti-bribery provision and the accounting provision. I'll leave a few of these slides for you to look at the trends in the enforcement actions. Well, there's vigorous desire to apply to all issuers of securities in the United States, including foreign companies that have level 2 and level 3 ADRs here or reporting companies. It's no longer limited, enforcement is no longer limited to corrupt payments. It really means anything of value. And the willingness, particularly of the SEC, to focus on books and records and internal controls when they can't find evidence of an actual bribe has become really, really glaring. Under the accounting provisions in 2014, the government sought and obtained a record number of settlements that simply charged accounting provisions violations. This is an area where the government is rabid, perhaps to say, on charging individual executives. Mr. Laugerman referred to the Yates memo and charging individual executives. It has long been SEC policy and DOJ policy to look for and prosecute FCPA individuals involved in FCPA matters, but I think, as I'll talk about in a minute, I think that this is one area where the government's track record of actually successfully bringing these prosecutions is somewhat tarnished and demonstrates the difficulty of bringing these types of prosecutions. The other thing that is driving FCPA tremendously is whistleblowers, and I'll come back to that. In 2014, there was not a record high in the total amount of fines that were brought, but there was a significant increase, not quite bringing it back to 2010, the year that Siemens and Daimler were resolved. But the average settlement per case increased significantly to $156 million, which is demonstrative of the government's desire to make this into a revenue-generating operation. Turning to enforcement actions against individuals, more than 80 individuals have been charged in the last 5 years in FCPA cases. And there have been a large number of pleas, there have been some guilty verdicts, and there have been some settlements by individuals. But this continues to be a source of significant consternation. In a case involving Alstom in Connecticut, involving a gentleman named Larry Hoskins, the government recently lost, just in August, a motion to dismiss the indictment, the charge relating to the conspiracy count for the FCPA. We can, perhaps in the questions, if we have time, we can go into more detail on that. I think that the message of that is, in the end, it is really difficult to bring these cases, and it is really, really difficult for the government to prevail. Two other big cases I wanted to talk about just for a second. BHP Billiton. BHP sponsored, had super deluxe seats for the 2008 Beijing Olympics. They invited 650 of their biggest business guests from around the world to attend. 176 classified as foreign officials. Of those, 4 accepted and 1 actually attended. BHP settled SEC internal controls and books and records charges for $25 million. There was no bribery charged in this case. The order cites the weaknesses in the company's compliance program around these foreign official invitations, and how some of the forms that were completed in order to obtain the invitations were falsified by lower level employees. And absolutely nowhere in the order is anything that alleges any type of quid pro quo. This is truly an example of taking what we would have all thought of 5 years ago as being a compliance control, a legal compliance control around the FCPA, and turning it into books and records and internal controls that now qualifies under the accounting provisions of the FCPA. Secondly, Bank of New York Mellon just last month was fined $14.8 million related to what was known as the Princelings investigation. In fact, Boney provided internships to 3 students who were family members of 2 officials of a Middle East government sovereign wealth fund in order to obtain and retain that business with the sovereign wealth fund. Importantly, these interns were not otherwise qualified. The bank went out of its way to specifically set up a program just for these 3 people. And if you want some real entertainment, read the order, because the emails there are glaring examples of what not to put in an email. Why are we doing this for these people? We wouldn't do this for anybody else. That type of thing. Again, the SEC alleged inadequate internal controls and extended those to hiring practices, and repeatedly cited the compliance program's failure to monitor whether the FCPA was being followed in terms of the company's hiring practices. The moral of the story here is the quid pro quo can extend to hiring, charitable donations, and anything of value, including a student internship. Finally, let me turn to whistleblowers. I don't need to explain the program in any detail. I did want to point out one thing on this slide. Increasingly, the SEC is seeing more action from foreign whistleblowers playing the lottery ticket, I guess is the best way to say it, of sending in a complaint to the SEC in the hopes that they might recover on that. I don't have it on the slide, but this year, actually late last year, the SEC paid $30 million to a foreign whistleblower. It never disclosed what the case was, but that is a tremendous incentive. And yes, exactly, cash the chip. And you can see here that high-risk jurisdictions, India and China, among other places, for corruption, have become the leading sources of foreign complaints coming into the SEC's whistleblower hotline about potential FCPA violations. That is what I had to say, and I did my father proud.
You did wonderfully. Hi, again, my name is Mauricio. I'm going to talk to you about cybersecurity trends, what we're seeing in the U.S., do a comparative on what we're seeing abroad. For me, I would like to start with the litmus test, and that is to say, I would have talked a little bit about the same sort of type of preparation that David, our keynote speaker, talked about. And if any of you who listen to him have been thinking, well, my client or my company doesn't have those things, a proactive information security, compliance, and response program with policies, procedures, technical requirements or controls, with an action plan, with these sort of arrangements in place, then I think you are at risk and you're vulnerable. And I think that what David described was just a sort of the basic, the foundational sort of preparation approaches. The fact is that this area is incredibly complicated. It has gotten very complicated just in the past 3 years, 4 years, not just in the U.S., but outside of the United States as well. In the U.S., the complexity arises from the patchwork approach that we take to dealing with the issue of cybersecurity. When I talk about cybersecurity, we're really talking about 3 distinct areas, and they sort of kind of blend into each other in the center. If you imagine sort of 3 large circles of spheres. We're talking about individual protections of privacy, norms of rights, and how digitized information can create these risks to individuals or consumers or financial services customers or patients. And the rules and regulations around the protection of data that sort of is intended to address that risk. And those in the U.S. we sort of view as individualized sort of privacy notions and protections against potential harms to the individual in the violation or disclosure of that information. It is really founded on the individualized duty to protect and the duty to warn. We'll talk a little bit about how this sort of shows up, particularly in foreign jurisdictions. Another sphere is about cybersecurity. It's about preventing cybercrime, about the protection of critical infrastructure, of national security concerns. It's about the protection of digital assets and value. And rules and regulations around the protection of critical infrastructure, of company assets, obligations that arise from statutory obligations to maintain soundness in financial institutions, or the protection of intellectual property to prevent from loss of that value. All these sort of fall into this big bucket of cybersecurity. And then you have a sort of separate bucket, and these are special arrangement buckets. There's special arrangements with governments that sort of write their own rules about protection of information as defined by regulation, industry rules that sort of address sometimes just privacy, sometimes security, sometimes soundness in different ways. For example, in the payment cards realm or the payments industry. And so what regulations apply to you and what you have to deal with in terms of risk and compliance and liability will significantly vary depending on what you're talking about. Is it individual privacy issues and concerns? Is it the protection of digital assets or cybersecurity or response to internal cybercrime or external cyber threats? Or are you in a special place where there are special rules that apply to you because you're participating in a particular type of arrangement or market? And so in the U.S., it's incredibly complex. We have a number of different varying approaches to dealing with this issue of privacy and security. We've codified in the U.S. This duty to protect, this duty to warn in different ways depending on the industry. So a good example would be financial services on the Graham-Bliley Act, where there's a duty to protect, and that is imposed in the form of regulation under the privacy rule under the GOBA, and the duty to warn, which is codified in this sort of security rule, also part of the duty to protect. We've approached healthcare in the industry and cybersecurity and privacy through through HIPAA in the HITECH Act. And there recently there was a new omnibus rule under that framework that updated a number of different provisions in HITECH and under HIPAA, particularly for the security rule and as it applies to business associates, those third parties that provide services and assistance for the provision of healthcare services. So certainly if you're in the financial services realm and you're dealing with cybersecurity and privacy, you're steeped into GOBA, the interagency rules, into the CFPB sort of view on financial companies' obligations to protect non-public customer information. But then there's other rules that are very sort of data-specific or record-specific in the U.S. So those will be, for example, the Fair Credit Reporting Act that talks about background and consumer reports. Or marketing practices that implicate privacy and security, like the TCPA, the Telephone Consumer Protection Act. And so in the U.S., what you're seeing is a patchwork approach to legislation in this area, and if you're in an entity or you have your clients that are servicing customers in the financial services sector, but also have a sponsored, fully funded health plan, but also have some network services that are provided to children, you're dealing with different laws that apply with different risks and different potential penalties and enforcement risk. And certainly to the extent that there are any services or products that touch on consumer consumption, the FTC has broad investigatory and enforcement authority for consumer protection in this area, and we're going to talk a little bit later. I'm going to talk a little bit later about the recent decision in Wyndham and what that means for any entity that has consumer relationships. And of course, a new entrant into the cybersecurity realm is the FCC, with very recent enforcement and steep penalties to telecom providers. And so, if you're providing a telecom service subject to FCC jurisdiction, you also have to worry about FCC enforcement, and that includes whether you're just providing services to consumers, and that's the sort of the source of the risk. The FCC's new open internet order means that this issue gets more complicated for broadband providers, and there's an ongoing discussion and debate about how the CPA rules, which is the consumer public network information and the protection of that information, get extended to broadband providers. Don't have enough space in this slide to put a host of other authorities that are looking and providing guidance and enforcement in this area, like the CFPB, the FDIC for financial institutions in terms of examinations, the SEC, who has provided a light of guidance to register agents and broker-dealers, the CFTC as well. And I should also just mention that the NFA had just recently proposed cyber guidance to NFAA members around cybersecurity, primarily focusing on the smaller players. On the next slide, to complicate this further, we have state-driven approaches. Because we like a federal comprehensive framework to deal with privacy and cybersecurity in the United States, a lot of, at the federal level, a number of states have really taken the initiative. And so we have about a handful of what I would sort of call, for lack of a better term, activist states, states that really try to prescribe a lot of legislation, regulation in this area. And so many of you know that there are some states that have comprehensive information security requirements, requiring companies that collect data about individuals in that state or conduct business in that state to implement comprehensive information security programs, like California, Massachusetts, and Texas. And then there are about 48 data breach notification laws. California has just recently proposed amendments to their data breach notification law. You might know this already, but California was the first state to implement a data breach notification law in the United States. And a number of states have followed suit, 48 and counting, and they vary. They vary in terms of scope of personal data included in the definition, the type of notice that ought to be provided to individuals or governmental authorities, the remediation that ought to be presented, whether there should or should not be law enforcement coordination, the kind of retention of the investigation and the period of retention of the investigation report. And so if you have a breach in the United States, you may be dealing with not just 48, I should say not just some regulators in the industry, but also 48 states. And even if HIPAA doesn't apply to you because you might not be viewed as a covered entity under HIPAA, state laws may nevertheless apply to you because you are collecting what might be very generally defined as healthcare information about individuals, including employees. So it's important to sort of think about dealing with the compliance risk, the enforcement risk, and the liability risk at a very sort of comprehensive level, both at the state and the federal level. And of course, there are data destruction laws, which vary from state, and in some cases they're uniform, but really it's about ensuring that companies that collect just a lot of information and electronic records, that they are disposed of when there's no longer a legitimate purpose for using them. Now, the trend really at the enforcement side is at the federal level, really is the sort of vertical regulatory agencies. So for consumer protection or any entity that provides consumer products, is the FTC. For financial services, certainly is the CFPB and a number of state agencies that vary from state to state. And for healthcare is the HHS and OCR. At the state level, the state attorney generals are really being very proactive in investigating and enforcing. Whenever these days there's a massive breach, typically what we see immediately is a coalescing of state attorney generals, typically Connecticut, New York, California, to really start to come up with a framework for investigating these national cyber breaches on behalf of all the other states. And so what you have almost immediately these days on a massive breach, that is one that implicates multi-state data breach notification or protection laws, is a multi-state investigation, potentially with multi-state enforcement. Of course, that can be sort of very complicated in managing and dealing with this. So it's important to be prepared to address multi-state investigation and enforcement when they come up. And there is a trend that started a few years ago, but now it's picking up steam. I'll talk a little bit about a Supreme Court case that's pending in Spokane and how that sort of may change this trend. But there's a trend in states passing legislation that provides for not just a general duty of care for the protection of personal information, like in Texas and California, but also to provide for statutory damages or private rights of action. And that certainly will complicate things quite significantly, particularly in pending litigation around Article 3 standing, which I get to and go through fairly quickly. So very quickly on private litigation, the trend here is that whenever there's a massive data breach that implicates either employee, consumer, or even or will sort of be contractual protections, there seems to be just a immediate sort of litigation that takes place, and primarily in class action. And so the class action litigation, notwithstanding very favorable decisions throughout the country that are pro-defendant, those litigation cases continue to come in, and that's because there are I think what I will sort of term as innovative arguments that are being made by the plaintiff's bar to try to survive Article 3 standing in a motion to dismiss. And many cases are settling because the cost of defense is, sometimes far greater than just settling some of these cases. And also there's a big trend on some decisions where I get to as well very quickly. But so when there is a massive breach, you can almost count on almost immediately on three things happening. Number one is you're going to probably get an agency inquiry and some enforcement authority, particularly if it's a national event. You're going to likely get some litigation, whether it be at the spectrum of the worst case scenario, national data breach litigation filed in multiple jurisdictions. We'd like to get some litigation. And the third thing you're going to get is going to be a business partner, customer inquiries, and a potential reputational hit for the company. One trend that I will note here is the Toyota Ford GM case, which was filed recently earlier this year. And I think that is the first real attempt to try to litigate consumer product liability in this space. And that is whether companies who are putting products into the stream of commerce have liability if there's a cybersecurity vulnerability in the product that they're sending. I won't go into the details of the case, but I think that that is the first test to see whether, in fact, there is some consumer product liability. On the next slide, let me briefly go through this sort of the three major areas of trends are in the U.S. and how that sort of it implicates sort of international operations. The first is that, for the most part, a lot of cases that have been filed in this space, particularly in data breaches, have been dismissed for failure to plead adequately Article 3 standing. And that is a requirement that injury, in fact, be concrete and particularized in the pleadings, that they are traceable to the challenged conduct, and that's likely to be addressed by favorable court decision. And this is all the standards that were articulated by the Supreme Court in Clapper. So most cases that have been are in the data breach realm have been dismissed for failure to state injury. So claims like emotional distress, concern over potential identity theft, concern over potential financial fraud, loss of value in one's data, all of these have been found by courts to be insufficient. And so, including some reimbursable cost on the basis that a plaintiff cannot self-inflict injury by assuming a lot of expenses in the hopes to sustain litigation if the injury that sought to be mitigated isn't imminent. And there is a bit of turning in the tide. Started with Adobe, with Sony, and now with Renegis and Neiman Marcus. There, the court, and what is viewed widely as a presidential ruling in the Seventh Circuit, found that allegations to recover sort of cost or to address potential injury with respect to future fraudulent credit charges or protecting against potential identity theft was sufficient to state a claim for Article III purposes. And reversed the district court's decision in dismissing that case based on prior precedent throughout various circuits. And in that case, the court sort of pointed out what is really common practice in the industry today when there's a massive breach in the U.S. and abroad, and that is to provide credit monitoring services, to provide assistance in terms of identity theft insurance, as a factor in concluding that the company must have thought that there was some real likelihood of injury to the class, and thus was sufficient to maintain standing. And there, some of the other facts it was a data breach, it was a credit card breach case, but 9,200 cards were associated with that were associated with the breach had been used fraudulently, and the company provided credit monitoring and ID theft insurance, and there was no guarantee that the plaintiffs can actually recover any actual losses to the extent that they incurred them. And I thought what was really important, and this is sort of the biggest takeaway in terms of a trend of what's happening in the U.S. in terms of litigation risk, the court sort of reasoned that the plaintiff should not have to wait until the hackers commit identity theft or some kind of fraud in order to give standing, because there is an objectively reasonable likelihood that injury would occur, and sort of pointed out that hackers kind of hold on to data, and this is well understood in the cybersecurity circles, that they kind of hold on to it for about a year and a half until they actually use it in a malicious way. And of course, as I mentioned, the court found injury in fact given by the plaintiffs getting, some of the plaintiffs and the class members getting credit monitoring services. So I think that sort of shows a sign of where things are going. Courts are more likely to sort of, given the high profile nature of these data breaches in the U.S., that the courts are looking for ways of giving plaintiffs their day in court. Now, I mentioned Spokeo, and I'll go through this very quickly, but Spokeo is up in the Supreme Court, and basically the question before the court is whether statutory damages in the absence of actual injury is sufficient for Article III standing. And there the defendants argue that imminent injury, and injury in fact is an absolute requirement under our Constitution, and that neither Congress nor state legislators can create a fiction of injury by imposing statutory damages. And so that the Supreme Court accepted cert, and so we're waiting to hear a decision on that. Obviously, that would implicate a number of states, including some federal legislation that does impose civil penalties and some statutory damages. And if there is a favorable decision, plaintiff favorable decision, that certainly the risk is that would create an opportunity for states to adopt a number of additional laws in this space that would provide for statutory damages. I also mentioned the Wyndham case against the FTC. The Third Circuit upheld the district court's decision that the FCC had broad authority to regulate and enforce data security, even in the absence of actual regulation or prescriptive requirements on companies. Another way to say that is that the FTC may bring enforcement action on consumer protection grounds for either deceptive practices or what they deem unfair business practice for lack of data protection or data security, merely by relying on prior enforcement action, guidance, and consent decrees. So the Federal Trade Commission, I think, will continue to plow away, and going to the slide here on its sort of statutory authority, to bring enforcement and investigatory actions against companies that either are alleged to have been misled consumers in terms of data privacy and security, or who have failed to adopt reasonable security measures in the protection of that data. And of course, I think that we'll be keeping and I would recommend you keep an eye on that litigation and see how, in fact, how reasonable security measures are actually litigated in that case. And then I just want to move. We're going to have some Q&A on appropriate responses, some best practices, some practical steps companies can take, and we're going to do a comparative on international developments and standards through a Q&A process. But what I will end now is on the SEC sort of view of this very quickly, which moving to the SEC slides. So the Commissioner Aguilera has sort of taken a very clear sort of view of this, and he's done that quite a few times now, and that is that the cybersecurity as an issue for public companies is one that must be addressed at the board level. It is an enterprise risk, and if directors are not looking at this issue and not thinking about the impact and how to mitigate these risks from an enterprise perspective, that is an issue in terms of breach, in terms of fiduciary obligations to the company. And they have put out quite a number of different guidance to companies around cybersecurity and reports of cybersecurity risks, including costs associated with preventing cyber risks, data breaches, proceedings with respect to data breaches. And what we see, and we've plotted this, is really a significant trajectory upwards of continuing requests by the SEC and more disclosures around the impact to the enterprise on cybersecurity, not just in terms of risk to the enterprise, but costs, impact of data breaches, and the approach of in terms of the risk of the company. So I put a quick reference here on the disclosure guidance, topic number 2 on cybersecurity by the SEC. I understand that there will be further guidance coming out from the SEC on these issues. Of course, there are a number of existing regulations that do apply to registered agents, broker-dealers, and others on implementing measures to protect the customer data. So that's just a really high-level overview of the sort of privacy and cybersecurity trends in the U.S. And as I said, we're going to really get into a little bit of the international scope.
Thank you. Thanks to all of our members of the panel. I'm going to kick off. I think we do have about 10 to 15 minutes left for questions. I'm going to kick it off with a few questions and then invite questions from the audience. And the first question, I wanted to tie a little bit of Grayson's presentation with yours, Mauricio, and talk about the discussion regarding the national security and critical infrastructure implications of cybersecurity that you mentioned and how that ties in with the CFIUS review. We know that currently, as part of the CFIUS outline, CFIUS does ask for cybersecurity programs for companies, for the U.S. businesses that are being acquired. How do you see CFIUS addressing cybersecurity issues in the future?
Want me to start?
Yep.
Okay. I think this is going to be one of the waves of the future development in CFIUS. You're right. They do have the question in there about what is the company going to be doing with cybersecurity going forward. But I think also there's another aspect of it in that cybersecurity is being viewed more and more as a national security issue. And so to the extent you have the threshold question of is there a foreign business out there that's acquiring a U.S. business that is engaged in sensitive national security issues, I think cybersecurity is a broadening realm there, both from companies that provide cybersecurity, companies that house sensitive information in a cyber format, and also a sourcing issue of who provides what cyber information and what cyber protections we have. So I think you're going to see it expand the definition of national security. I think you're going to see more attention being paid to that question of what is the company going to be doing going forward. And I would not be surprised to see it being more and more of a mitigation measure that's being required to be put in place. And it already is to a certain extent, especially when you have the FOCI issues we were talking about earlier, to protect classified information. But I would not be surprised to see the government getting its experts involved in making sure that there are plans in place to protect any sensitive information or any government-controlled information that could now be being acquired by a foreign company.
I absolutely agree. I think that what you have, and this might be obvious to many of you, but when the company, the U.S. entity that is going to be foreign controlled, is in a critical infrastructure space, you get a lot more questions, a lot more attention, a lot more follow-up to that inquiry. We had a number of clients that had to provide not just the cybersecurity mitigation framework that exists in the U.S., but how that's supported from outside the United States. And controls that will be put in place, both administrative, technical, and operational controls. What are the key dependencies between the foreign entity and the local entity? What autonomy exists within the local entity, not just for the protection of assets that are used for critical infrastructure services, but a lot of data, a lot of information, particularly if there is a compromise of the shared service organization that exists outside the United States. It could get very complicated. Certainly, to the extent that the local entity is involved in government contracting work, the questions are really even quite more exacting. In fact, we see a lot of this in the telecommunications and satellite communication space, where the questions when it comes to CFIUS review and approval is how is the standards that are U.S.-based going to be maintained for cybersecurity and electronic and satellite communications, particularly where the communications facility is being supported outside of the United States. And so so it could be quite exacting. You have to sort of be ready to address these issues in a very detailed way.
Thanks. A question for Henry. Given all the high-profile prosecutions for sanctions in the FCPA that we see happening, are you surprised that the cases keep coming up? I was interested in your discussion of how the recent case regarding the intern program did not involve a quid pro quo, how cases are turning into be more books and records cases. Do you think that the cases will decline eventually as companies implement more policies, or is the government just going to continue to change the way they're enforcing the rules?
Well, I think it broadly falls into, if you look at the trend over the last 10, 15 years in FCPA enforcement, there were a spate of cases involving originally many Texas-based oil services companies operating internationally. That led to some cases involving some European companies. There have been, I would say, a steady flow of cases involving non-U.S. based companies that for one reason or another still haven't gotten the message. And I don't think that's in my mind, that's never going to go away. With respect to U.S. companies, you do see less of the, I'm talking in very broad terms, less of let's go to Nigeria and conspire to bribe somebody kinds of cases, and you see more of we had somebody at the end of the pier. We were trying to do business in China. It was difficult. We needed to get a license. We needed to get a statute changed, that kind of thing. And now those cases are starting to work through, but now they are becoming kind of less of the big conspiracy cases and more of the one-off cases. And I suspect that human nature being human nature, greed and avarice continue, and corporate pressure to make profits in remote markets that aren't performing well continues. And I think, this is just human nature. I think at some point you reach the point of saying there's just going to be a steady diet of them. And I think in the sanctions area, the more complicated sanctions law gets, the more it's used as a tool of foreign policy, the more likelihood that you'll have, not to use Commerce Bank as an example, but you'll have foreign institutions that will view that they can exploit what they consider to be business opportunities and what the U.S. government and others think are illegal acts.
Thanks. I'll open it to the floor.
Well, I've been accused of a few things, never been in the 1950s.
Mauricio, let me summarize the question for the people on the webinar. The gentleman in the audience is asking about the Ford and GM case and the cybersecurity breach and Mauricio's reaction to that and how it may not be consistent with the discussion of the SEC commissioners trying to get out ahead of cybersecurity issues that maybe Mauricio reacted that the Ford and GM case wasn't that serious of a cybersecurity breach such that the automakers should be responsible for it.
Well, I don't think I reacted in any positive or negative way about the case. I just merely reported it that case has been filed. It's the first one where there's an attempt to deal with cybersecurity as a product liability warranty issue, and that's a trend that we're likely to see coming up. We don't have enough. We could probably spend a whole day just talking about that case, all the allegations of the plaintiffs in that case, and how the courts are likely to sort of deal with those issues. I think it certainly is important, and that is an area that we'll just see continue, particularly as the Internet of Things, as that proliferates, where you see a number of connected devices, device-to-device connectivity, risks. So your characterization of dismissal, I think, is unfair. I don't think that I try to dismiss any case or any particular pending or trend that's taken place. It's just merely pointing out to you that there are trends that are taking place and that the law in this area is evolving. You know, the defendants made a very clear argument in that case, and it was many-fold argument. But the first is that there's been no hacking. No one's crashed. No vehicle has stopped. Whether that succeed or not, I don't know. We'll see how the court decides. But certainly it's a serious issue, and that's why there's litigation, and that's why, you know, it's funny. I went to the recent convention in Vegas, which I don't know if you guys are familiar with. It's called DEF CON, and DEF CON is a hacker convention. I take it so serious that, in fact, went there particularly to talk to the hackers that are hacking into the vehicles, and had a nice small roundtable to learn exactly how they're doing this and where do they see the vulnerabilities. For the obvious reason is to be able to advise our clients on what actually is going on and what are the major risks in this area. This area is going to evolve. The Internet of Things, as I mentioned, is going to create a lot of complexity. Three things you have to understand about this area, and certainly we can never do it justice in a 2-hour or my 30-minute discussion. And these are the fundamental truths that we see today in this space, and the GM case sort of shows this. Number one, nation states are incredibly investing in getting digital information, whether valuable or not. They just want to gobble as much as they can get their hands on. That's happening everywhere. Our government is doing the same thing, I predict, but certainly it's happening from abroad. Number two, organized criminals see a significant value, and they're always going to be investing a lot of money and effort and try to be able to get and monetize this information they're collecting. And hacktivists, some say, always also be ahead of the game. The law is always going to stay behind. The law is always going to play catch-up. It's going to require, you know, a lot of guidance from regulators, unfortunately litigation, and an evolution of best practices, which have to be adaptive and dynamic. And so that point could be made about any of the litigation that we're seeing, not just the GM case, or any of the guidance that we're getting from governmental authorities. And so my recommendation, and I think to underscore what I think you're saying to everyone, is there is evolution taking place in this space. There are serious risks that are at hand. None of it ought to be dismissed. I absolutely agree with that, and no one would disagree with you on that. And it requires a compliance, risk mitigation-driven, holistic, enterprise-wide approach to this issue in terms of proactive response, not reactive. If you're still in a reactive mode, you're in danger. You have to be proactive in this space, particularly if you're multinational. So that's a bit of a long-winded response to your question, but hopefully I've answered it to your satisfaction. Good. The nod is yes.
This is a general question. So if I'm an American business and I get my data stored on a server, and in the case of the company, some places the company practice and I used to have a log that would show frequent hack attacks and the Chinese government that kind of knowledge. Then we moved the server to Virginia and kind of get different attacks. The general question, like somebody successfully hacked into my space, is the fact that the server is Hong Kong make any difference to me?
The general question is, if your server is being hacked, does it matter whether it's located in the United States or outside of the United States from a legal perspective?
Absolutely. It matters a whole lot. It matters from an investigatory perspective. To sort of give you an example, you have sort of, let's say you have an ongoing investigation. It's kind of an internal corruption case, but there's some circumvention of systems that folks, employees or others typically try to hide their tracks, so they go in and start messing around with systems. The systems might be located in a foreign jurisdiction. And so whether you can get data out, where you conduct the investigation, what kind of law enforcement coordination is necessary, whether you have to do notifications, who has a protected right, all that is jurisdictionally based. And so it does matter a lot where the servers are located, where the data is, where the individuals live. It can be very complex. In today of cloud computing, you may have massive amounts of data stores located in multiple jurisdictions, primary backups, spread out throughout different jurisdictions. And you may have a breach where it implicates multiple jurisdictions. And it may be systems that are integrated, virtually, but are located in different jurisdictions. So one event can trigger, compliance issues throughout multiple jurisdictions, multi-law enforcement coordination in multiple jurisdictions, notifications that vary from jurisdiction to jurisdiction. So it really matters a whole lot, and you have to have a good understanding of your data footprint to understand if something goes wrong, what's going to be your response, and what's going to be, how do you discharge those obligations.
And one other thing that I'll throw in there, because you mentioned that the identities of who was hacking you may change as well wherever you're located. It could make a difference from a sanctions or an export control perspective too. One of the concerns you have is if you have data in the United States, it's going to be controlled under U.S. export control laws, even if it didn't originate in the U.S. If it's foreign developed and it's now in the U.S., it's going to be controlled. And if you have a foreign entity hacking into the U.S., that's going to be an export at that point. And you have issues as to whether you took the steps you needed to protect it while it was here in the U.S. And it could be, some of the stuff that David was talking about earlier. I think we had our former prosecutor asking about how do you silo off the going to the government as a friend versus while the government's in there helping you out and they happen to notice, well, you didn't follow A, B, and C rules in protecting your data. Are they then going to use that to prosecute you? And it's, David said what I understand the government's line to be, which is we're not there looking to further victimize you. But man, before you call the government, you give them open access to everything you've been doing. It's something I've had to advise clients on, and I know a lot of my colleagues have as well, as to trying to get your arms around how you invite the government in and what protections do you have at that point in trying to make sure that it doesn't turn into a bigger issue.
All right, because we started this panel a few minutes late, we'll go a few more minutes to address any other questions. I see one in the back. Barbara? The question is, given the tension between the SEC requirements for disclosure when there's a material event such as a hacking and the needs for quiet to investigate and determine what's happened, is there any guidance on when the disclosure needs to be made?
I can answer that. So at the state and under federal regulation for certain industries, there isn't just guidance, there's a regulatory requirement that you facilitate law enforcement, and you get a safe harbor. So a number of state notification laws, if law enforcement tells you not to notify because of an ongoing investigation and you don't notify quickly, that's a safe harbor for under the statutory timing requirement. There's also some guidance both from the FTC, from the SEC as well, that law enforcement interest and coordination are very important, and the trend has been to allow that to happen where it's appropriate, not to use as an excuse to delay notification, but where it's appropriate. And the fact is that the relative risk to the enterprise for purposes of public reporting evolves over time. It isn't always clear at the first instance whether in fact it could have a material risk to the financial performance of the company or to its assets. and that requires an investigation and oftentimes law enforcement coordination. I do find that in my experience that a lot of law enforcement organizations, including at the federal level with the Bureau, is that they really are moving away from delaying notification and providing some kind of notification in order to allow individuals to take steps to protect against identity theft, against financial fraud, and the like, while continuing to conduct an investigation. And so I think it's probably all over the map in my experience. Some of the massive data breaches, there's a lot of very quick 72, to 4-day investigations at 24/7. And oftentimes that is sufficient in order to isolate, to remediate, plug the holes, if you will, while allowing a lot of law enforcement activity within that period of time to then provide some kind of notification. The other complicating issue I would also add is that there is a different approach among states about the timing of the notification. And some have provide a statutory timing requirement. Others have not and said, as soon as practicable, or some will say immediately, but except under the following circumstances. And so, unfortunately, you do have to take a look at all the different states and some of the federal regulations that are applicable and some of the guidance. But I think the trend is to allow for law enforcement investigations.
And just to add on to that real quick it depends on also what's hacked.
Right.
If you have classified material that's hacked, it's almost immediate. DSS wants you to go to them immediately. Mm-hmm. If it's controlled under DoD with a DoD contract or something along those lines, it's 72 hours at this point, and you have to secure all the information. And one of the real practical ramifications of that is, when you find out, and we've had situations like this where we've had to advise clients, you find out somebody's been breached. You don't always know where that breach went to and what it got to. And so if you have a company that has a division that does DoD contracts over here and then has a purely commercial division over here, when you have a breach and depending on what they had access to, it can be very difficult to figure out whether, what obligations you have because what do they have access to. And that can be the first obstacle and first real difficult question you have to answer is what did they get their hands on? What was exposed?
That's right. And on the private side, I would also add that you may have a contractual obligation as well. So you have to look at if the contract gets implicated and requires immediate notification. Sorry.
The securities lawyer in the room will just point out quickly that in order for a plaintiff class to make a case for failing to file an 8K quickly enough, they have to allege scienter intent and that you were doing this intentionally. I've never ever in 25 years of doing this, I've never seen a case successfully allege that cooperating with law enforcement constitutes intent to commit securities fraud.
Right.
Any other questions? One more and then we'll break.
Let's hear your thoughts on cyber insurance.
The question is, what are our thoughts on cyber insurance?
Sure. So it's still evolving. I think that the number of companies are still trying to figure out what's the right way to, create a product. A number of insurance companies, AIG is a good example, where they came up very early into the market with cyber insurance. The early policy seemed to provide some duplicate coverage in some areas where some of the injuries were already covered by general liability, E&O type of insurance. That's still evolving. Given Commissioner Argalar's public statements, given a lot of the emphasis, particularly by the National Association of Corporate Directors, on cyber insurance, you just seen recently an explosion of a lot of different types of policies. We talk to and work with a lot of insurance colleagues. In fact, we have a specific team that just deals with cyber insurance. It's probably unfortunate for me because I know enough to be dangerous. There is still some uncertainty, particularly in exclusions, whether there's first-party or third-party claims. So I think that you have to work very closely with your broker. But I think that not having at least gone through the evaluation of cyber insurance coverage, particularly if you're in a high-risk area, it's a real problem. I think you do have to go through that process of evaluating whether cyber insurance is appropriate and the type of product that would work for the company. But these days, whenever you reach out to a carrier, an insurer, and you want cyber insurance, you get a questionnaire. Sometimes what I've seen now, a trend of actually doing these mini audits, mini assessments of your cybersecurity posture. So cyber insurance isn't something you just inquire. You have to be ready for it. And it means that you have to look at the program you have, what kind of cybersecurity preparedness state you're in, because you're likely to get a lot of questions and a sort of mini audit of where you are before they underwrite.
Thanks. I'd like to thank our panel. I'd like to thank everybody who joined us here in person and on the webinar. And I'd like to remind you, as Andrew Sherman mentioned at the beginning of this program, that we'll have our year-end regulatory roundup and forecast on December 15th from 4 to 6 p.m. I think we'll be discussing some of the very subjects we've discussed today in that program as well, and cocktails will follow. Everybody have a great day.